Hi guys, it's Kathy. We made it to the weekend. Yes, sir. Hi, Walter. We got some crazy court for you and some Judge Fleischer. Because we have not focused enough on Judge Fleischer since he started streaming again. I didn't. It's me. I know it's me. Don't worry. But we're going to make that up tonight. So here, let's start though with Indiana where it's just bad. But I have to forward this clip once he gets to a certain part because I tried to cut it 3 times and save it 3 times and it just doesn't listen to me. It's okay though. It only take a second. Judge Sanford. Uh-huh. Oh my God, Bill's here. Hi, Bill. How are you?
So what do we do? We move forward sentencing today?
I'm still asking, Your Honor, because he has the trial date and the record date here coming up quickly for sentencing to be set out so that he can be sentenced on around the same time, if that's, what's going to happen with regards to that case. So that it may be in the court's best interest to do so, just because, if he has to do another PSI, go through that process, it may be in the court's best interest to push it out to be able to send some at once with regards to both cases.
The other case now.
The other case, Your Honor, is, and I'll let the state speak to that.
Hey, excuse me, Ms. Christopher, what's the other case, Mr. United States? What's that entail? Oh, you don't know, that's Mr.
Yeah.
It is attempted battery by means of deadly weapon and then criminal records. That's all the vibes.
And we have a possession of a machine gun, right? I don't know, Miss Alba, I mean, what? Your client seems to be more of a danger to the public than anything.
Well, I mean, Your Honor, those are allegations.
I get your allegations, ma'am. I did the sort of work you did, but the fact of the matter is, usually people, they're gonna screw up, they screw up after their sentence, not before. And your client's decided he wants to put the cart before the horse. So why should I cut him any slack? He obviously doesn't care that what happens with him with his future, because he's decided he's gonna go out and again allegedly commit another offense. So why would I take a chance on him committing yet another offense? I'll tell you what I'll do. When's the trial date?
Trial date, Your Honor, is set for May the
May 7th.
7th.
Okay, so if there's no trial May 7th, sir, you're getting sentenced. And why shouldn't he go into custody? What's your bond on the other case? We don't know because Mr. Britton's not here. You weren't a GPS, sir?
No, sir.
Guess what? You're going into custody today and you're going to remain in custody until they put a GPS on you. Where are you living?
My girlfriend.
Your girlfriend. Well, okay. Well, you're going to remain in custody until they put a GPS on you, sir. And if there's any other issue with you, sir, you're going to remain in custody until all your cases are resolved. I think you pose a threat to the community. So we'll set sentencing for May 8th. Well, we'll set it for May, let's see. Oh. How old are you?
20.
Yeah. You know what prison would be like for somebody like you?
What's up?
What?
No, sir.
Well, you know what? You may find out. You keep going down this road, it's exactly where you're gonna head. Prison. And let me tell you something, you can look down your nose at me right now, but you'll be looking at something else in prison. And it won't be nice, it won't be pretty, and you'll come out much worse than when you went in. They don't.
Your Honor, a quick question for you about GPF. Do they go and visit him to set that up?
Yeah, they'll go to the jail, hook him up, and then
Okay.
he'll be free to go then.
Okay,
He's in custody until he set up on
so they do
GPS.
that. Okay, all right, thank you. Okay.
Don't you worry. I don't. I won't.
Football.
I can't believe the
Right.
judge made that poor man go to jail. I cannot. This guy. Guys, we don't have enough rum to play this next guy. Here we go.
2017, let's see. Back in 2017, 9 years ago, you entered an admission violating your probation. The lawyer asked for a supplemental pre-sentence report. It never came back.
I had selfish reasons and noble reasons. It was my mom's. I knew I had messed up. I really had a hard time figuring out what was going on in my life. I know I wasn't doing it on the best behavior, but my mom was also in the grips of COVID. She had passed a few years later.
Well,
But I know I wasn't doing-
Wait a minute, sir, please don't insult my intelligence by telling me that you were concerned about COVID. COVID didn't even rear its ugly head.
No, I'm talking about that's no,
We're
Your
talking
Honor,
about
no, Your Honor, that's why I
2017.
never came back. I know it was
But
about.
you didn't come back in 2017, 3 years before anything happened with COVID.
My mother was sick, Your Honor. And I said it was no reason. I didn't need any such intelligence. Yeah, I'm trying to figure out what was going on. It was so long. My mom
You
passed.
said Mr. Berger was your public defender, was he?
Yes, sir.
Well, he's retired. So we have to appoint a new public defender. You're gonna be held without bond. I think you have 2 cases here.
Yes, sir.
And I'll reappoint the public defender. I don't know that's necessary. Well, I don't know. Well, let the lawyer make.
Your Honor, can I say something though? I am now currently enrolled into the housing program. That's how they picked me up.
Mhm.
And there was a 2017, it was 2019.
No, sir,
I'm sorry. I wasn't
you
I
first.
wasn't trying to blow smoke at you. I just,
Yeah, you keep talking. When you're done talking, you let me know.
I'm sorry, I'm done talking.
But, sir, in 2017, his mom was suffering from COVID. He can't turn himself in.
Your next court date will be March 18th. When you,
I do have a home and a job, sir. Can I get bond?
no,
Why not, sir?
because you've been gone for 9 years. 9 years you were gone. And if you hadn't been picked up on a warrant, you'd still be out. You came into court, you entered an admission. I continued this over so we could do a dispositional hearing. You didn't show up for 9 years. That's why. See, the purpose of bond is to make sure, 1, you show up in court, which you did not do, and 2, that you don't, to protect the public from you. Now, I don't think that the public,
Okay,
hang on.
I'm sorry.
I don't think you've done anything that the public needs to be concerned about, although the robbery is a concern. But the fact you didn't show up in court, that's why you don't have a bond. Now, I'm sorry that messed your life up, but if you'd taken care of business 9 years ago, this wouldn't even be a concern. See you on the 18th.
Then will I be able to get bond, sir?
No,
What
no,
was
you're
it?
gonna remain in custody until this case is resolved.
And the 18th is not when it's gonna be resolved.
No, I don't think so.
What if I pay off all the fines?
Nope, I'm not bargaining with you, sir.
No, I'm
Go
just
on,
asking a question.
No,
I'm asking-
no,
Okay, sorry about that.
yep,
Thank you, Your Honor. I'm a changed man, sir.
no, I'm good.
I am, sir.
That's why you turned yourself in, right?
No, I enrolled in the
That's
program.
my point, sir. That's my point.
No, the program.
Changed man would have turned himself in. We're done. I'm not gonna
When
discuss.
I enrolled in the program, I knew that you guys
We're
were
done.
on
We're
board.
done, sir. Thank
All
you.
right, sorry about that. I don't want to start off with a bad foot.
Too late. I'm a changed man. I'm a changed man, sir. Let's go here.
Good morning, sir. All right, this is State versus Rodolfo Lopez Jr., 2409 F5 334. Mr. Lopez appears in court as a self-represented litigant. State appears by DPA Beckley and Soto.
At least I gave you a court with better carpet.
Mr. Beckley, are you handling this case?
Myself and Mr. Stiglitz will be, yes, Judge.
All right. So in this case, Mr. Lopez, the record reflects that you are still dealing with the matter in LaPorte County. Is that correct, sir?
That's correct.
All right.
Released on bond?
Have you been released on bond in that case?
Yes.
Okay. So there have been several motions that have been filed, but the one at issue, Mr. Lopez, this morning is on December 19 of 2025. You filed a motion to dismiss.
That's correct.
The court issued an order on December 19, giving the state until January 19 to file a response and set it for hearing on January 20. The court set it on that date because when it looked at your case in LaPorte County, that appeared to be a date that was between dates. And the court believed if we could get you back here to address that.
They did come to pick me up. I refused it only because I wanted to deal with the case in LaPorte County and the LaPorte County case. That date fell on the same day as this date.
Yeah, what happened was in the interim, you'd had another.
Just think how fun it'd be trying to walk across it. You have to put your foot here, then you gotta put your foot here. Then you gotta put your foot here, you gotta put your foot here. It covers the blood stains.
Date set on January 20.
Yeah, the thing is I
So-
set that date, but
Okay,
I wasn't concerned about this case because I wanted to deal with that case first, which I did. And I
all
bounced
right.
out.
So the record reflects that you actually requested that date in LaPorte. And then when we came to get you on that date.
It was set by the
Transfer.
state and I
Okay.
didn't object.
So what happened was when January 20 came, we were advised that you had a conflicting date. So I had reset it to March 17. You had filed a bunch of other orders as well, and then I issued sort of a summary on February 3rd. Now, you did file most recently, Mr. Lopez, a motion under Trial Rule 53.1 saying that I failed to rule on that motion to dismiss. You captioned it, sir, under 71 DO2 1801 F5 334. That was actually the other case that had been charged back in 2018, but was dismissed. So I think you meant to file it in this case.
Well, it was filed under the correct cause number by the clerk, but 1801 should be placed with 2409 is the actual correct number.
All right, that's right. Okay.
But the clerk did file it under the
Yeah,
correct cause
I just
number.
wanted to clarify, and I think we all knew that that's what you meant to do.
Yeah, and I also filed one of these against the LaPorte County. I mean, to keep it short, I've been incarcerated for a year and a half. I'm doing prison time in jail without any conviction. So I'm trying to stop the back
You doing prison time in jail? Are you? Is that what you're doing?
and forth is like almost insanity between counties.
Well, I certainly, I mean, I would,
But let me explain the 53.1.
sure.
I've already filed it. The clerk is actually required to send it to the Indiana Supreme Court. That should have already been done.
Correct.
But, okay, so the motion to dismiss was filed December 19, 2025. The state was given 30 days to respond to the motion. The state did not respond. The defense received no response by the state or the court within the 30-day, which would have been January 19th, 2026. The Chief Administrative Justice shall
But he didn't show up for court. he didn't show up for court. So no, the state didn't respond.
Review the motion and ruling, if any. Furthermore, the appointment of a special judge shall be granted to the moving party. The likelihood of them appointing a special judge is not likely, and it takes 2 months for that process to happen. But since I already filed it, that process should already be going through. As far as the motion to dismiss, the court is actually, it was under statute, the court is actually supposed to grant it or deny it. The fact that I wasn't here may be a plausible reason on your end, but as far as the ruling, the state statute under the Rule 53.1, the court rule, states that the ruling should become within 30 days.
Well, Mr. Lopez, you've kind of already anticipated, or you've stated what I'm going to say.
Right, I
Is
mean-
when you file that, the only reason I wanted to clarify the cause number, but you have, and we all knew it was this case. I just
Right.
wanted to make sure.
Right, I
So
mean-
what has to happen, Mr. Lopez, is yes, the matter is technically out of my hands. I can't rule on your other motions.
Correct.
The matter does have to be referred to the chief administrative officer to see if a special judge needs to be appointed.
Right.
So I can't act on any of the other things that you have filed.
So
So
any motions that are filed after that, so everything's on pause.
correct.
Okay.
So that's what I'm going to do is refer the matter, or at least tell the clerk that the matter needs to be referred to the chief administrative officer.
Because as far as 53.1, I don't see anything about pausing any other motions or any rulings.
Well, the problem is once that issue is filed, technically it has to go to the chief administrative officer and I can't do anything. So I can't rule on anything.
Because
Mr.
I
Lopez.
did that on the LaPorte County office, judicial officer. It was denied after 2 months. It was on a right to go pro se, pending a competency hearing. It was
Correct.
denied because I filed it early, because I filed it 8 days early. But, and then they also argued the motion that a pro se,
Those are the rules.
argument shouldn't be filed under 53.1, should be argued in a higher court, et cetera, et cetera. But it was still a failure to rule on a motion.
Sure.
Regardless, okay,
Et
so you're
cetera, et
saying that
cetera.
everything is paused, including the right to speedy trial, everything. How about,
I can't do anything is
Okay.
what I'm telling you.
how about
Yes.
a bond hearing? Can't do anything.
No, I mean, you've had a bond hearing, so bond is set.
Well, the thing is, I haven't had an actual bond hearing, a bond review hearing. Like,
Well, that happened to the arraignment, Mr. Lopez?
okay, so I filed a motion on the 2nd and the 13th for a bond hearing. The last one I filed was a motion to compel a bond hearing, which I was in St. Joseph County Jail as of the 2nd of February, since I bonded
He
out
filed a motion to compel bond hearing.
of
Well,
LaPorte County. Requested bail hearing set for the defendant incarcerated over 15 months continuously since September of 2024. Bail had been set at initial hearing at $15,000 cash bond. The same day a bond investigation was conducted and the scoring of the defendant was at low risk. The state affidavit filed a requested bond at $10,000 cash bond. The defendant has not had a bail review hearing since in 1.5 years. The defense moves to compel the court to set bail hearing as soon as possible. Also, if I am eligible and released on bail, I'm requiring no GPS as my residence location is in LaPorte County, and Mr. Lopez, myself, has been released on 10% bail on restricted status in LaPorte County. So
Again,
Just so you know, it wasn't like he was just sitting in jail for 15 months. He had competency issues that he had to work through.
Mr. Lopez, I mean, I've tried to set hearings on the motions. I've tried to respond to your motions as soon as they're filed to the extent I can. Some I have to allow the state an opportunity to respond. So in this case, however, because where we're at procedurally is that you have filed the 53.1, is I can't rule on anything of yours. Okay? So I have to refer this, or the case is rather needs to be referred to the chief administrative officer for a determination as to whether or not the case needs to be removed from me and a special judge be appointed.
I mean, the chances of that happening is very slim. It's most likely not going to happen. So it's really it's a violation of due process in my end.
Again, Mr. Lopez, I have to do what,
So then could I withdraw it? So I'll request to withdraw that 53.1 since has the clerk filed it like she's supposed to?
well, I suppose this is what you can do. I'll confess to you, Mr. Lopez, I'm kind of in uncharted territory here. Okay.
I know, I'm aware.
So
that
what
you're not-
what I would need you to do, which you're certainly very good at, is to file that in writing.
Okay, I'll file a motion to withdraw.
But I'm going to need to confer with downstate to see if
Well, the thing
this is a bell that can be unrung. Do you understand?
But the thing is, if the clerk hasn't filed it, because it's supposed to be on the docket that she filed it with the Supreme Court. If it has not been filed, then I have a chance to
Well,
withdraw it. And
I get that,
I'll
Mr.
move to
Lopez, but here's the
withdraw.
deal. The clerk not filing it is sort of I mean, I don't want it to
Thing is
turn
not-
around after the fact and
Right,
you
the
say,
thing-
hey, you know,
Thing is,
Judge
it's not-
Francisco, you violated my rights because you needed to send that down to the
Well, it's another
state.
violation of rights if we don't proceed, though. That's the thing. So,
I get it. That's why, like I said, first of all, I need it to be in writing.
okay.
First of all, dude, none of this is a violation of your rights because you did this. You keep filing motions. Then you don't show up for the hearings. You did all this. You put everything on pause when you said that we need a new judge. And now you have to wait for the chief judge and the Supreme Court to make a decision on the judge. So you did this. It's not a violation of your rights when you did this.
Secondarily, like I said, I need to confer downstate to get
Okay.
their opinion on that. Okay.
They'll probably agree that it shouldn't continue because it hasn't been filed in their court. So
That could be. Now, let me ask you this, Mr. Lopez. When is your next hearing in LaPorte County?
I requested a transport order on the 9th of this month, last month, and it hasn't been denied, so she'll most likely approve it, but I had requested that she wait to see if you set a bail hearing. So she's
Okay.
probably most likely waiting until the court hearing is for the 12th. So I'll most likely be transported next month if I don't bond out
Wait,
here,
the 12th of March or the 12th of April?
12th of March. So
Well, you're
next,
probably going to be transported like
next week.
probably this week.
I don't know which courtroom he went to. He keeps saying she. I'll find it. Don't worry.
Most likely next week. Well, if
I
she
don't know.
sees the hearing on the docket, then she'll most likely issue
Well,
transport.
technically, I can't really enter an order right now. I have to have you file that. I'm just going to,
Well, I mean,
I'm going to enter a docket entry that we had this matter to clarify.
Okay.
Will indicate that you intend to file a motion to withdraw, but the court needs to confer as to whether or not
Yeah.
it needs to
So
be
you're
sent
still in-
downstate. But it's not going to be an order per se.
So basically, it's under advisement, basically. Similar.
I'm hesitant to say that. I just want to make sure that the entry, Mr. Lopez, will at least provide some reflection of the conversation we've had here.
Okay, so most likely LaPorte County will transport me either this week or next week.
It's possible that they might before I have an answer and can actually issue an order.
Yeah,
okay.
they most likely will. So
If they do that, Mr. Lopez, I suppose I could just look this up, but do you know your next date thereafter?
that's it. That is the 12th is a status hearing, and we were proceeding depositions at that time.
Is this case?
So basically, the case is set in status.
Is there a trial date
With
in-
depositions, no, the case is set in status only, and depositional hearings are proceeded,
Well,
which was my next move for this case.
That's not how they roll in Indiana. They set your status. They set the omnibus date. Then they set the trial. They set it all right away when you get first arraigned. If everything's set up.
okay, I see that. Well, what will happen then? If I'm not able to get this resolved before the 12th, it'll be resolved, or at least I expect I'd have an answer shortly after the 12th and would bring you back.
I'll send a motion to withdraw. Well, they have to bring me back, after the case.
No, I understand that. I just,
Because I'm released from there. This is the hold here. Or I actually got a warrant still issued, which was another one when most
All right.
recalled warrant.
well,
Too bad the judge can't get rid of that warrant, sir, because everything's paused. Because you said you wanted to get rid of the judge.
I suppose to make a long story short, if you intend to withdraw your 53.1 motion, you should file that in writing so we have that reflected in the CCS.
Okay.
I will see if I can get an answer downstate as to whether or not we can do that. And if that's the case, then I'll set you another hearing as quickly as I can. Now, it may be after March 12th, depending on, I don't want you to miss that hearing, obviously. But then, yes, we'll get moving forward on what's going on in this case if we
Yeah, the
can.
back and forth is just, it's tearing this whole system apart. I mean, it's prejudice on my, from what I see.
Well,
But
Mr. Lopez,
you did it.
I mean, I
You did it.
originally wanted to try to get the case resolved here, but you had told me throughout that you wanted to take care of the LaPorte County case first, right?
To an extent.
Okay,
To an extent, until they threw in determination of competency, and that threw everything off. And.
well, to be clear, I did not enter that order.
No, you
sir.
didn't. You authorized pro se status, but the same, at the hearing, counsel, public defender requested competency status at the same time I
Jailhouse
objected
lawyer.
and requested to move pro se. So I mean, all of that would have to go to the appeals court, which, beyond that, okay, so I dealt with all that. I closed all that out. I proceeded pro se and moved for deposition. Got bond hearing, came here. So basically that's the status. And the next move as far as defense in my status and my standing is to move to dismiss this case and proceed to LaPorte County. That is my move for
Okay.
the stance on defense of this case.
Okay, well,
There you go,
again,
Mr. Prosecutor. Did you hear
First
that?
thing I need to get past is the 53.1
Withdrawing the
motion.
53.1, I'll file that. I'll send that out as soon as possible when I
Okay.
get back. And then we'll proceed with the other motions. As far as the motion to dismiss, I'm going to go ahead and file an amended portion of it with more details.
I just
Okay.
got done
And
putting this carpet in my living room, Salty. What, it's not good?
Memorandum.
Well, file the withdrawal 53.1 first,
Yeah, I'll do that.
and then let me get some guidance. All right, so
And my judge's bench.
anything else that you want to tell me right now, knowing that I have limited ability, Mr. Lopez, to act, at least as we sit here right now?
As far as the early trial, that was more of a motion to compel the court to set a hearing. And basically, I'm waiving the early trial. I'll be honest with you, this case will never go to trial because I have the option to go to Veterans Court. But I'll use that as a very last option, as the very least option.
Well, Mr. Lopez, again, to make the record clear, and I mean, like, you've filed a lot of motions and I have tried to respond to them as quickly as I could.
No, you
I think
haven't.
in this case, I've issued now close to 20
Yeah,
orders.
you've done it.
If Mr.
Oh yeah, my living room walls aren't that empty. There's a divorce decree sitting right on my wall. It's almost the only decoration.
Mr. Lopez, you are withdrawing motions such as the 53.1, the speedy trial request. I would just ask, sir, that you do that in writing. To be honest with you, I've been trying to keep track, but at some point, if I'm able to hear the case, I'm going to have have you let me know what you think is still pending, because there are so many motions that have been filed. And because you were in LaPorte,
Okay.
I've not been able to
No, I agree with
have
you.
substantive hearings to
Agree.
allow you an opportunity and allow the state an opportunity to present arguments.
Yeah,
So,
I-
Mr. Lopez,
yeah.
if there are other motions you are wanting to withdraw, please file those in writing just to make it a little clearer on the record. All right.
Judge, how is he supposed to tell you which motions are still open? He doesn't even know which motions he filed because he's in jail. He can't just pull that up on a computer.
Anything else, Mr. Lopez? I'm going to give Mr. Beckley an opportunity to speak.
Well, let them speak and then I'll speak. I'll go ahead and speak.
All right, Mr. Beckley, anything you want to say?
First, Judge, I would direct your attention to 53.1 sub H regarding time periods that may be affected by the filing of Mr. Lopez's motion and what happens to that filing if multiple pleadings are then filed subsequent to the request to have it removed from your consideration. That may affect your phone call with Indianapolis. Number one. Number two, I was under the impression that the court was going to set trial dates this morning. That's why I wanted to come down myself. I understand the court's not willing to do that at this point. Fair enough. I guess from the state's perspective, it may need to respond to the motion to dismiss at some point. Once it's amended, we request the opportunity to do that. And just so the court's aware, I understand that Mr. Lopez has been granted permission to proceed pro se. I think this court can and should appoint counsel anyway for Mr. Lopez. That's under the authority of Edwards v. State.
And I'm objecting.
All right, well,
You're going to need to make some factual findings if we get to that point, Judge. So at some point, we'll file, once this court determines its ability to act and issue orders again, the state will file something outlining that position. I just wanted to give you a preview of where the state
All
is
right.
at currently.
let me, the first thing you said, Mr. Beckley, you were drawing me to 53.1 subsection H as in Henry.
H as in Henry.
So I don't know if I have a different version of the rules than you, but I am looking at the Indiana Rules of Court 2026, and I don't have an H.
I'm looking at Indiana Rules of Court on the internet.
Okay. Hold on.
Yeah. It appears to have been very recently amended.
Judge, did you turn it over? Is it on the other side? Maybe H is on the other side, Judge.
Well, I guess there's a reason,
sir.
Mr. Lopez.
Your Honor, I have an idea. Your Honor, if you have a question about what that statute says, why don't you ask the defendant? He can teach you.
Lopez that for whatever reason that version is not included in mine, but subsection 53.1H, Mr. Lopez reads, it's captioned or titled waiver and tolling. 1, if the requesting party files additional motions, correspondence, or pleadings after filing a precipice.
I'm only 50% sure that's the real Snoopy. See, because he always used to say something specific that he wanted, and he hasn't said it once in the last couple of days that he's joined. He hasn't asked not one person to do it to him.
The requesting party waives the right to remove the judicial officer from the case, and the precipice is void and of no effect. Once a precipice is filed, all time limitations are tolled until resolution of the precipice. All right, I still want to at least call down
Look,
state.
they didn't go to
For some
ChatGPT.
reason, I don't know why
So
that's
that's
not
good.
in my printed version. If it's something that actually exists or is not in effect yet, I don't know.
I have an effective date. Again, this is according to the website. If you scroll back up to the title, effective February 2nd, 2026.
Okay. Oh, well, that's probably why, because this was printed beforehand. So there may be, Mr. Lopez, I just want to make sure I know you want it withdrawn. I just want to make sure that.
What's the conclusion according to that update?
I'm sorry?
What's the outcome according to that update?
No, I just read you what the new version of the rule reads.
Right, it's a little confusing. I'd have to read it again, but basically it's saying that there's a toll on.
Well, first of
any
all,
other
it's saying,
motions.
since you being the requesting party, if you file additional motions after you file the precipice, then you're waiving your right to remove me from the case. And the precipice is void and of no effect.
Okay, so then that.
Which is kind of what you want to do.
So basically, I've already waived 53.1 then.
All right. And then it says, once the precipice is filed, the time limitations are tolled until the precipice is resolved. All right. So here's what we're gonna do. I still want you to file this in writing,
Okay.
all right? And
Yep.
this may be the way where I get the case just going again as quickly as I can.
Yeah, I've never seen that. Part
I have
of it.
not either
Yeah.
because apparently that
It must
was
be a new.
just went into
yeah.
effect because it's
Must-
not in the printed version.
Well, then the other question is, did I file it before the new effect took place? So I mean, that'd be another question too, but I'm not gonna linger on about that.
All right.
Uh,
Well, Mr. Lopez, we are trying to get you to the point that I think you want us to get.
I just
to.
want to proceed
I
because
get
the
it.
next step is depositions.
I get it. All right, and I kind of want to
And
move
then
your
now
case along.
he's throwing in, taking me out of the Sixth Amendment right to wait
Well,
counsel. which
First of
I've
all,
objected.
Mr. Lopez, yes, I know, you object.
You're the one that appointed me, pro se.
I did, and I went through the advisement. I note you were, there was a
Judge,
cop.
we are all holding you in contempt of court right now. 6 months.
Competency restoration in LaPorte County. I mean, you have argued, I think, the law fairly well to me. You have filed motions. So, Mr. Beckley, I understand your position, but I'm not going to remove Mr. Lopez from defending himself absent a motion and some sort of hearing.
Well, of course.
Because right now, I mean, Mr. Lopez has demonstrated to this court at least the ability to navigate the trial rules. And he files motions, he's making arguments on his behalf. You know, whether, I guess I'm just going to leave it at that. If you feel like that's an issue, then you need to file a motion. I just want people to file motions so that I'm not doing things that are just popping up out of the blue on the CCS. Understood, sir?
Basically, you would be contradicting yourself if you deny me.
No, no,
pro
Mr.
se
Lopez, I'm
anyway.
not telling you I'm gonna remove you from
No,
your own
I'm
case.
saying I'm arguing against the state,
Yes.
against your own judgment.
Well, we're not having that argument yet.
Okay. Yep.
But Mr. Lopez, I think I've at least indicated that you have demonstrated in court an ability to defend yourself. And so I'm not going to
Okay.
just do that. But
Okay, so
as with anything, Mr. Lopez, if it requires a hearing, I'm gonna have a hearing.
Okay. So as far as proceeding the case, I'll file the motion to withdraw. Can we set a hearing?
First off, Judge, if you set a hearing, he's not going to come to it. Second, Judge, he's asking you for a hearing right now. Guess what? He ain't gonna come to it.
Within March to reset?
Well, here's what I'm gonna do, Mr. I do have a trial today and I have one on Thursday. And I expect that I'm gonna be tied up on that. But I do want to get clarification on subsection H.
Okay.
It's my intent, Mr. Lopez, to turn this around as quickly as I can.
All right, it'll take
Now,
at
I'm
least,
aware you have the March 12th date in LaPorte, and that has caused problems with this court, the most recent being the fact that I had picked the January 20th date and we couldn't have you brought back. But I am eager, Mr. Lopez, to get this case moving forward.
my priority.
You have a lot of, you have motions that if I'm able to rule on,
Mhm.
I'm going to rule on them. You have a speedy trial motion.
Mhm.
Right now, the time technically is told, but once the time is untold, if I'm able to do it, it is my intent to give you that trial date within what's required by the law. Okay? There's also some issues you want in terms of depositions, things of that nature. So there's a lot that I would like to get going on this case. Okay?
Just to set a status hearing, like I said, I would waive the early trial.
Well, again, I'm asking you that you file that in writing, Mr. Lopez, just so
There's no
that,
such thing as waiving early
you know,
trials,
the-
sir.
the chronological case summary looks clear. Okay?
I'm
Right.
requesting the clerk also send, see, I'm gonna be back and forth. Just send it to this jail, for now, the affidavit, charging affidavit, and, a copy of the chronological case summary.
Well,
If I
we
can.
can print that out now. Ms. Mobbin, can
Okay.
you go ahead and print out a copy of the chronological case summary and what else did you
The
want?
affidavit of charging
And
information.
the probable cause affidavit.
Also, I want to
We
address.
can't
the-
have it stapled, Mr. Lopez, but we'll
That's
give it.
fine.
we'll
Can
print
I
it to you.
address the state also as far as discovery? And the first discovery, can I address the state as far as discovery?
Well, I can't be involved in conversations between the parties.
Okay, great.
So,
It's just discovery of evidence. I'm just requesting a duplicate copy because the first issuance had every other page. The second issuance that I used to compel in December, they're missing page 6. So I'm requesting a reissuance of discovery and complete discovery copy of the documentation. It's about 8 pages or so.
all right, well, Mr. Beckley heard what you have to say, Mr. Lopez, so.
Mr. Beckley's just sitting there with his arms crossed because
I'm
he's
sure gonna
lost.
get you what it is
He's
you need.
confused.
All right, well, we have to give you, Mr. Lopez, there's one version that has an address, so we have to give you the one that does not have the address. You understand that, sir?
What is that?
Probable cause affidavit?
Oh, yeah, yeah.
All right, so
That's
Mr.
fine.
Hoppin, print Mr. Lopez the redacted version of the,
So there's a no contact order and a $15,000 bail. So he beat someone up. He aggravated assaulted someone, I bet. I don't know.
it only takes out a couple of addresses, Mr. Lopez, but you should be able to understand what the allegations are based on
Yeah.
the rest of the document. So just sit tight. We're gonna get these printed out.
Okay.
Anything else from you, Mr. Beckley?
No, Your Honor.
You want the information too?
Sure. Whatever's included
So the
with it.
CCS, the charging information, and the redacted.
Why would the prosecutor do anything? Because this guy's doing his job for him.
Probable cause affidavit.
I had a question, Your Honor, since we have time.
Yeah.
The subpoenas that I requested for deposition, the clerk would file it, but the notice for deposition, proceeding to deposition, I would request that the clerk also file the
He is a charming fellow. Well done, champ.
notice of deposition due to the redacted case. I can't have no contact order. Could the court also issue, she'll issue the subpoena for deposition, but can't she also issue the notice for deposition as well?
Well, yeah, essentially, Mr. Lopez, what the notice does, it provides the other party with an opportunity to appear and take questions as well. Of course, we can't issue the subpoenas on the deposition because right now you've been in custody in LaPorte.
But I mean, I'm saying if we set a deposition
So
date.
the way I envision a deposition, now, that's still a matter that's pending that we set for hearing, but if there is a deposition in this case, I suppose the way the court envisions it is it would be conducted here in this courtroom. That would be how I would understand, or maybe
Okay, I would
remotely.
put it-
I don't know. Mr. Beckley,
I
might
have
wanna chime
requested,
in.
the state prosecutor's office, which is done in LaPorte, that's how they do it there, but here or anywhere, yeah, would be fine as well.
okay,
What I was
I
requesting.
want to address all these, and frankly, I didn't even know you were in the jail until it was brought to my attention,
Okay.
because I originally had this set for a couple weeks down the road.
17th.
When it came to my attention, Mr. Lopez, that you were in fact in our jail, we set this for today because I'm
So
wanting to move
basically,
forward.
I'll end up going to LaPorte, and then when you set a hearing, I'll be brought back here.
Yeah. Now, Mr. Lopez, we have printed out. Yeah. Beckley, I have the redacted version of the probable cause affidavit, which has redacted out the addresses.
Correct.
And I have the,
Besides lawyer, I want a job that I can carry a little suitcase around like that everywhere I go. Besides lawyer, what job could I get?
the chronological case summary in this matter, which is Mr. Lopez, 18 pages in length. I have the charging information, Mr. Lopez. So, we're giving you copies of what you need. Okay, anything else, Mr. Lopez?
That's all for now, and that's.
Anything else, Mr. Beckley? All right, Mr. Lopez, I expect that I will probably see you in short order then, sir.
All right, thank you.
All right, thank you.
I think the judge is going to definitely set some hearings quickly as soon as that statute 51 or whatever is ruled upon, because I think he wants this guy gone. He wants all of his cases out of his courtroom. So, what time is it? It is. All right, let's do this. This is what we're gonna do. We're gonna go to Judge Fish. Fish.
State, would you please set a record?
Yes, Your Honor. Thank you. This is State of Indiana versus Robert Jenkins Jr. The cause number is 64D012603F52582.
Dibs.
Defendant appears in court in person by video conferencing. He is here with counsel, Mr. Ken Elwood of the Public Defender's Office for our Criminal Rule 2.6 purposes. State of Indiana by Gary Gurman.
Morning, Mr. Jenkins. Can you hear me okay?
Yes, sir.
First, I'm required to advise you of your various rights in this matter. You have the right to hire an attorney to represent you. You have the right to have an attorney appointed to represent you if you cannot afford an attorney. You have the right to a public and speedy trial by jury, and you have the right against self-incrimination. That means you cannot be forced to make any statement or testify against yourself at any hearing or trial held in this matter. You understand those rights as I've just gone through them?
Yes, sir.
So you've been charged here with 3 counts. Count 1, possession of methamphetamine, a level 5 felony. This cause states that on or about March 8th, 2026 in Porter County, you did knowingly or intentionally, without a valid prescription or doctor's order, possess pure adulterated methamphetamine, and the amount was at least 5 grams but less than 10 grams, contrary to statute. You understand the allegations in count 1.
Does anybody know if at least 5 grams and under 10 grams is personal use or not personal use?
No, sir.
What don't you
Or more
understand,
than
sir? Were the
personal
words I
use.
said or what they mean?
I'm saying there's just, I didn't have no 5 grams.
Mr. Jenkins, this isn't the time for you to argue the facts of the case. What's important is for you to listen to what I read off from the criminal information, the charging information.
When he gets really mad at someone and he's about to nail you, yeah, he smiles. It's not pleasant. It's very terrifying.
And let me know whether you understand what they say you did.
Dude, hi, my love.
Yeah, I understand.
Oh, so you do understand what the charges are, sir?
No, I understand what they're saying. I just don't
Okay,
understand.
well, sir, I need you to not talk about the facts and circumstances of the case, because every time you do that, you jeopardize your defense. Do you understand me, sir?
Yes, sir.
So I purposefully talk over you so that the recorder doesn't pick up what you say, right?
Thank you, sir.
Okay, yeah, what's important is whether or not you understand the charges. Do you understand what they allege in count 1, that you're in possession of methamphetamine, at least 5 grams, less than 10 grams?
Yes, sir.
Okay, and it charges a level
It's all right. Monica, you already answered the question. Monica, what's the answer? Hey, Jude. That's the answer.
5 felony,
My
which
coffee's
carries a
here. I'll be
possible
right back.
sentence of 1 to 6 years in prison and up to a $10,000 fine. You understand that possible penalty?
Yes, sir.
Okay, count 2 alleges possession of marijuana, a Class B misdemeanor. It states that on or about
I get it. Monica, he said, I asked if 5 grams but less than 10 is more than personal use. Is it or not? And Brad wants you to answer that.
March 7th, here in Porter County, you possessed marijuana. Do you understand the allegations in count 2?
Yes, sir.
And it's charged as a Class B misdemeanor, which carries a possible sentence of up to 6 months in jail and up to a $1,000 fine. You understand that possible penalty?
Yes, sir.
Count 3 alleges possession of paraphernalia, a Class C misdemeanor. It states that on or about March 6th, 2026 in Porter County, you did possess an instrument, device, or other object that you intended to use to introduce into your body a controlled substance. Do you understand the allegations in count 3?
Yes, sir.
And that Class C misdemeanor carries a possible sentence of up to 60 days in jail and up to a $500 fine. You understand that possible penalty?
Yes, sir.
As required by statute, the court will enter a preliminary plea of not guilty for you on counts 1, 2, and 3. Do you plan to hire a lawyer in this case?
I don't have the funds.
Would you like for me to see whether you qualify for the public defender?
Yes, sir.
Please raise your right hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes, sir.
Okay, thank you. What do you do for a living?
I'm unemployed right now.
When's the last time you worked?
Several months ago.
And when was that? Several or 7?
Several months ago. It's been since before October, so it would have been
What
September.
were you doing then? What were you doing in the fall before you lost your job?
I was doing construction.
Construction?
Yes, sir.
The weather breaking here, could you go back to doing construction?
I would not. I'm looking for work now, or I was looking for work.
And how much do you earn when you do construction work?
At that time, I was only earning about $10 an hour.
$10 an hour?
Yeah, I was just cleaning up.
How many hours a week were you working?
Back then, probably about 15 or 20.
Do you have any money set aside from when you were working at that job?
No, sir.
How do you make ends meet on $150 a week?
I was homeless.
Okay. Where do you stay now?
I'm just staying on a couch at my aunt's house.
Do you pay her any money or anything?
I didn't have none. No, I didn't.
All right. I'll find your indigent. You qualify for the services of the public defender. I'll appoint the Porter County Public Defender Service to represent you. Mr. Ken Elwood's here today from that office to help me make some decisions about your release from jail. Mr. Elwood?
Thank you. Mr. Jenkins, is there an amount of bond that you can afford?
No, sir, I don't have no money. I could ask my dad, but he'd probably be like $100. And if I could get that.
Have you failed to appear for court in the last 2 years in any other court?
No, never.
Judge, I don't know if there's a hold out of Marshall County. I think he's on pretrial there.
Yeah, I'm sorry.
What are the charges there, sir?
No, they're already resolved. I just got to sign. There's a plea agreement to sign, and it's just a fine.
We don't save. This
Judge,
is
I'd
America.
ask for OR release so he can deal with the Marshall County case.
See?
Your Honor, the defendant's prior criminal history is difficult to summarize, but he has convictions in Illinois, Wyoming, and Georgia, Illinois, and in Indiana. Most notably, on December 6th of 2004, he was sentenced to 30 years in the Indiana Department of Corrections for a robbery, but there were multiple robbery cases filed in Marion County and one in Hancock County as well. The Hancock County case also had an habitual offender enhancement count that was dismissed. He does have a pending case, as has been alluded to, in Marshall County for driving while suspended and possession of marijuana. I show that case set for April 15th, 2026. The court set bond at $2,500 cash when the case was filed, and I think that's appropriate.
Thank you, State. Yeah, Mr. Jenkins,
I looked it up. So apparently, it's a gray area. Could be personal use, could be distribution, by the law. Okay, the law really says once you get higher than 5 grams, then that's probably distribution. And then ChatGPT says personal use versus distribution, real world, not just the law. 5 to 10 grams of meth is way more than a single use amount. Could be heavy user stocking up. That would be personal use. Or someone involved in dealing.
comfortable with the bond I set when I reviewed the case here. I'll let the bond remain at $2,500 cash only. If you post that, I won't put you on any pretrial release. That's fine. But I will set you over for a couple hearings. The first one's going to be an omnibus hearing. That'll be on May the 11th at 9 a.m.
See?
Second one's a pre.
See? They set these right away. So that other guy was a liar. Sorry.
Trial conference. That'll be on June the 8th at 9 a.m. Your order to appear for both of those dates. And you should reach out to the Public Defender Service today as well so you can get started with your defense. Do you have any questions about anything?
Yeah, Judge, I haven't been in trouble in over 20 some years, and he said I had cases in Wyoming, and he's outright wrong. I've never been convicted of no case in Wyoming. I didn't have no.
Mr. James,
more or less than
an
already on the bond
wrong
question.
about the
Set your bond
information.
at $2,500 cash, and I've set you for some hearings. I've appointed an attorney for you, and that's all that I need to do for your initial hearing today. We're adjourned.
But he
How many
just gave me
centimeters are
wrong
on the gram?
information though. But he was wrong. If you could lie to them and then.
How many grams fit into a football
I don't
field?
understand if you lie to him, I can't point it out.
We like to measure by washing machines.
What am I
There's
saying?
7 washing machines wide.
I think Jason Craig.
Then if the guy's wrong, he gave me wrong.
Actually, Americans will measure by anything except grams. Like they will 7 coffee cups wide, 7 dinner forks wide. But no, don't give us kilometers. No way. That's ridiculous.
Maybe Pingle too. Jason Craig, statement please set a record.
Yes, right. This is State of Indiana versus
I
Jason
can't
Craig.
believe the prosecutor lied on that man. We need to start a petition. That poor man getting lied on by a prosecutor. I'm just going to get rid of this clip because it's been sitting here for a while. Let's just watch it. I don't remember what it's about. I know there's peeing in a tent. I was going to use Dunny in the title, so it just sat there because I never did. So let's just get rid of it. Let's just go eat it right now. Granny has humor. Oh, look at the carpet. This is a different camera angle of this carpet, guys.
Morning, sir. Morning. So you're here for initial appearance on your charge. Have you been advised what the charge is in the new case, sir?
Yes, I received a slip this morning in my cell.
Okay. And was that a copy, when you said a slip, is that a copy of the charging information or is that just a notice of what the actual name of the charge is?
I don't know.
Okay, let me read these charges to you then. The charges indicate that on or about the 21st of February 2026 here in St. Joseph County, state of Indiana, Joseph David Hess III did knowingly or intentionally peep into the occupied dwelling of another person, that being EC, with intent without the consent of EC, which is contrary to the form of the statutes in such cases may be provided. Further, that is a
I know, Bren. Just tell me how many grams, like the size of your brain. How many grams different body parts on you might weigh, and then I'll know how much a gram is.
voyeurism is a Class B misdemeanor. Further, on or about February 21st, 2026, here in St. Joseph County, state of Indiana, Joseph David Hess III did knowingly or intentionally at the above location, a public place, fondle his genitals,
Like a
which is
gerbil?
public indecency as a Class A misdemeanor.
Ooh, it's like a capybara, only much tinier. It's like this big.
And finally, count 3, alleges that on or about the 21st of February 2026 in St. Joseph County, state of Indiana, Joseph David Hess III did knowingly flee from Canada Cone. A law enforcement officer with the Mishawaka Police Department after the officer identified himself by visible or audible means of ordering you to stop, making that resisting law enforcement as a Class A misdemeanor. Each Class A misdemeanor is punishable with fines up to $5,000 and up to a year of incarceration.
He
The
might
Class
only
B
have
misdemeanor is
one.
punishable up to 180 days of incarceration and fines up to
It goes from here to
$1,000. You
here.
understand those charges and the possible penalties, sir?
Yes, sir.
Okay.
Bren, look in a mirror. Can you count to 2 eyebrows? We have to know.
Some other rights that you have a right to a public and speedy trial by jury. You have a right to remain silent, which is a privilege against self-incrimination. That is, you cannot be made to testify against yourself at any hearing or trial in your case. The court will enter a preliminary plea of not guilty for you on all counts. It will become a formal plea of not guilty 20 days from today, unless after talking with an attorney, you decide to enter a different plea. You have a right to be represented by an attorney, and if you intend to hire your own attorney, you must do so within 20 days from today. The reason for this is that there are deadlines for the filing of motions and raising of defenses, and if those deadlines are
Unibrow.
missed, you may give up the right to place certainly.
Okay, JK, except I have a strong suspicion that a standard bag of sugar here and a standard bag of sugar where you live are two vastly different sizes.
Legal issues and defenses before the court.
Do you need two hands to pick up your standard bags of sugar there?
You have a right to have an attorney appointed to you at public expense if you cannot afford your own attorney. And again, that has to happen within 20 days. Is it your intention to hire a private counsel, or would you ask for the appointment of a public defender today, sir?
Higher.
Okay, very good. Well, then we'll need to pick an court date and discuss your custodial status. The other thing I wanted to advise you of is you had another cause number that was in pretrial diversion status, and that status didn't expire until February 28th, 2026, which is just a few days from now. However, the state has alleged that you violated the terms of that pretrial diversion agreement, and that they would like to revoke that
I didn't mean
agreement.
to
and
attack
have
your
you
manliness.
answer for those charges. So you have both of those causes in play now, and we need to set up a bond on all these matters today. State a position on bond.
Yeah, Sharon, it looks like the court did grant the state's petition to revoke bond in the older pending misdemeanor case. And at this juncture, we do believe that Mr. Hess is a significant danger to the community. He was participating in a pretrial diversion program and then committed a very similar offense and arguably almost worse. So we're asking that a much higher than standard bond be assigned, if any, in the pretrial diversion case, the older misdemeanor, and in the new case that a higher than standard bond also be issued.
Mr. Hess, would you like to be heard on the issue of bond? Go ahead.
Before last year, never experienced anything like this before. I maintain my innocence, Your Honor, and I don't think I pose any significant concerns to the community. I volunteer. I'm active in my church. I live at home with my wife and my dog, and I'm not gonna go anywhere. I've never gone through anything like this before. So.
And the court will offer this. It also notes that in the newer case, there is a no contact order. It is a term of any release. So if the defendant is able to post bond in the newer case, we'd ask that he be placed on GPS monitoring.
Thank you for the action statement. All right. So, Ms. Draper, was there anything from your side that needs to be heard?
No, Your Honor, I'm just here. Questions can.
Okay, thank you. Right. In light of the circumstances, sir, the court's going to set a bond at $3,000 cash only. Both
AJK,
of these
that is
that's an
helpful.
aggregate bond.
Now, just to get me over the finish line, how many grams do you usually take when you do meth at one time? Or does it vary from person to person? So like if me and Terry in Maine go to a bar, 2 different amounts of alcohol are going to be consumed that night. So you can't really average out how many drinks per person it takes. But can you average out what one hit of meth might be in grams? Or however else you want to measure it.
In both matters, you can post that and then you'll be out, but your next court date will be an attorney appearance date. We'll give it a couple of weeks here. Come back on March 11th.
V absolutely has a soul, 100,000%, and it weighs 20
Yeah.
grams.
Great. And no contact will be ordered with EC, the victim of the most recent offense. Obviously, it would be wise not to have any contact with anybody that's mentioned in these cases. Let's set an ominous date, let's see. To have one set
People
on
are him,
record
Monica. He is people.
for April 29th.
Judge, if I may,
May,
the CM 128 is Attorney LeBray on that case? Are
he
we,
has been entered in as the attorney of record on that case.
so is this more about, 515 today?
It is, but 128, the state moved to revoke the bond. The court granted that. So we're not addressing that case except for
For the
to have
bond.
it tracked with this case. We actually have another hearing independent on that case that's set.
Bren, I have a question. I'm just learning the word you taught me yesterday, okay? The way I used it today with you, was that better or worse than if right before the stream ends, I say, Bren, bye champ? Which one would have hit the best? I just need to know.
Coming up, and that hearing stands also. All right, so the court is going to grant the state's request as a condition of your bond. You'll also have to get hooked up to the GPS monitor before you're released. Okay, that'll be pretrial services. So pretrial supervision. We'll enter that over to you. All right, any other questions, Mr. Hess? No. Okay, thank you. We have a paperwork from the contact.
I'm super mad. Guys, that clip has been sitting in my little box for weeks now. And I still don't know. I wasn't paying attention to any of it. I missed the whole clip. I still have no idea what that clip is about, and I'm about to just delete it because I'm not gonna watch it again later. I had my chance to watch it with you guys and I lost it. All right, we are going to, going to Judge Fleischer, guys. I have a backlog of Judge Fleischer, so this is, we did play, I can't remember what day it was. It was either the 3rd or the 10th. We did play a docket of Judge Fleischer a couple days ago. This is one more tiny little clip from that day and then the next day. That's what we're watching today. Not the whole docket.
Frank Garibay.
Just last name, please. Who is it?
Garibay, Garibay.
Okay.
Okay, so he went over to do his drug test today. And his first appearance was on February 16th. He's explained to me that he hasn't smoked anything since that day. So it might come up, it probably will come up positive because, you know, it takes 30 days for that marijuana to get out of your system. But he hasn't done anything since that. His phone was disconnected. His phone was broken, so he got a new phone number, which I have. And he can give to the pretrial services if they need it.
Did you send him?
You don't have to get a whole new phone number. If your phone breaks, you just need a new phone, right?
Garibay?
Yeah, he went this morning, Your Honor.
And?
Deeply, deeply pensive. Maybe on her monitor at the top, she has a virtual fish
We
aquarium.
ordered him not to use, Dan,
She's watching the
on
fish.
January 12th.
Yes, Your Honor. And
We're
he's-
now 3:10.
right, and he hasn't had anything since February 16th. The thing is that I've talked to him. He's dealing with some anxiety, emotional things, and I know that there's other medication that he should be doing. That he can go to a psychiatrist to get. That's what I think he should be doing. But
I cannot imagine that a psychiatrist is going to tell him to willingly violate the law, especially.
Terry, if me and you could go out for drinks, which we can, because we live close enough, I could drive right up there. We would have such a good night. Yes, yes, yes. I would aid in your delinquency, but it's okay. It's fine. At our age, we can handle a few run-ins with the law. We can. The law will look at our record and say, oh, don't do that again, and then we'll be fine.
No, he's got 2 open criminal cases.
No, I get that, Your Honor. I'm just saying that there's other medication that he can take for anxiety instead of marijuana, and he hasn't had anything since February 16th, and so that's in a way it's a. I'm just asking you to give him one more chance on this, and if something comes up.
What do you want, Dan?
Just one more chance for him, just to make sure that he's not.
How long are you asking for? I'm not going to do 30 days because he's already had 55 days.
No, I get that, Your Honor. If we can do a week, 2 weeks, 2 weeks.
Fine. I will give you 2 weeks. If at the end of 2 weeks, homeboy.
Terry, we got to go out and drink because I have to prove JK wrong on this one. Okay, I will be the one who gets arrested. You don't have to get arrested with me, but I will be the one who gets arrested. And then I will be the one who just comes right home. I get arrested, they'll look at my record and they'll say, now come on, you just had a wild and crazy night, don't do it again. And maybe I'll have to pay a fine, maybe. I mean, as long as I don't murder someone. What if I just broke a few things in the bar? You know, what if rage came over and I just broke up Barstool? Then the police would come and then the judge would say, oh, I see you, you have rage. Okay, you can go home now, just don't do it again.
Continues to test, his butt is going to jail.
Sounds good, Your Honor. Sounds good. I'll talk to him.
No, where is he not here?
No, he's there. He's there, Your Honor.
Arabay, come up.
No, that was probably for Victoria.
I am extremely upset with you. Not only are you testing positive, but you fail to appear and you're failing to stay in contact with pre-trial services. It is your responsibility to stay in touch with them if
Okay.
you lose your phone.
All right, then you break the law and I'll bail you out. Yeah, I'm a celebrity. 12 people know me. I'm going to tell the judge that too. Judge, I know law. Judge.
If you change your number, they tell you that you're supposed to let them know. Baloney, because
And then JK will have to apologize and tell the whole world that they must take legal advice from me and only me. Don't read the law books. They'll rot your brain.
I have you here that you failed to show up again. I'm giving you 2 weeks. If you ever fail to show up or fail to show in contact or remain in contact with them, it's really
Shut up,
not
JK.
going to go well for you. Do you understand me? 2 weeks.
I would like to say.
I don't.
Frank,
Your
don't say
lawyer?
anything. Frank,
Do
I'll
you know
talk to you.
how many excuses I hear a day, Mr. Garabay? Hey, Take a guess how many excuses I hear on any given day. If I had one strand of hair for every damn excuse that I heard, my hair would look like this. Go.
Thank you, Your Honor.
Mr. Crosby, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 3rd in Harris County, a traffic stop was conducted on a vehicle for failing to signal a lane change. The driver only had a Texas ID card and no proof of insurance. Officer looked up the defendant's license and found that it was suspended for having multiple unpaid tickets and creating false plates.
Okay, can you run his license now?
Yes, sir.
Please, if you don't mind. Mr. Crosby, I'm going to find that there's probable cause to go forward with your case. I want you to understand.
I made a background of this jacket, I don't know, a year ago. Right here. I don't like it. It doesn't look right as a background. But I did make a background out of that jacket like a year ago.
Dan, I want you to hear me loud and I want you to hear me clear. I don't give a rat's behind what you have to do in this life. You don't have a license and you don't have insurance. Do not drive. If you do, I'm going to put you in jail and I'm going to make your bond extremely high. You will be signing an affidavit with me today promising me you're not going to drive. I don't care that you have to go to the hospital. I don't care that you need groceries. I don't care that you have to go to work. You drive. You understand me?
Oh, it'd be a lovely carpet idea, wouldn't it?
If you go get your license and insurance and you bring it back to me, I will happily take this off. But if I find that you drive, it's going to be HE double hockey sticks to pay. You understand me?
What are you talking about? I'm a master of FX.
You have the ability to hire a lawyer. You have the ability to hire a lawyer. How do you support yourself? What do you do for a living?
I sell drugs.
Okay, how much money do you make a month?
$10K.
15 what? Okay. I can have you apply. Deputy Williams will give you an application for a court-appointed lawyer. I don't know who you have in this life, but if I make your bond $10,000 to $20,000 and you don't have anyone to pony up that kind of money, you'll be stuck with me for a long time. Do you understand? All right, well. Hey, John.
I'm gonna get Jamie.
Hey, does Gia need a translator?
Yeah, but she doesn't.
I like it better like this instead of the full docket because
Luis is
everything
here.
is
Luis,
there's no
I'm waiting for someone to come in and then we're gonna talk.
because you don't have to sit and wait for all the pauses in between cases.
Mr. Oscar?
Yeah.
Mr. Barrientos?
No, a different one. Okay, tell me.
Judge, under Mr. Graves, he said, he's in the office.
Okay.
Yeah, so Mr. Graves was supposed to be picked up no later than yesterday, and we reset for today for pickup. However, the transport agency, unbeknownst to us, was not able to pick up because at some point it's understood that he was supposed to be diagnosed with MS, multiple sclerosis. And so.
What do you mean supposed to?
Because this is coming from the demand jurisdiction, I have not had the time to confirm with the jail. I looked inside our database and I haven't seen such a diagnosis. And we just.
And they're coming us on the day that they're due to pick up?
So so they have been here at some point. They never did tell, the transport company did not inform the demand jurisdiction. So we had no way of knowing this. And again,
why does he get to pay for it? Why does he have to pay for it by sitting in jail any more than he needs to?
Well, if the transport company, I believe them, they came and they were unable to pick up
Who
because.
gets the benefit of the doubt when someone's in jail?
And so, and that's the thing, I was hoping that we could get a carryover.
Not you.
Of course. I was hoping we could get a carryover to verify this information, Your Honor, because.
Regardless, even if I let you carry it over tomorrow, perhaps even the next day,
Eileen, I'm telling you this to help you. You are overthinking this. He is going to welcome you with open arms. He's going to be stoked to see you, super pleased. He just is.
there's no way they're going to get here within a day or two to pick them up.
And so that's the next thing, because of multiple sclerosis, he can't do the ground transportation, which was originally ordered. And so now they're scheduling flight transportation.
There's no way they're going to make it within a day or two to come get him. And it's a failure to pay child support. I'm not going to hold him any longer for that. If it was a capital case, it's a failure to pay.
That is a capital case, sir. No, you hold him until he pays his arrears. Make him work in the prison till he pays his arrears. Sorry, guys.
Child support? No. And they come in here the day when he's due to pick up?
Yes, sir.
Nope. I'm gonna give him a PR bomb.
Okay, thank you, Judge.
Yeah. You, up here. You. Please. Okay, I need to tell you. Over and over and over. At what point does it stop? I guess you don't get it.
I will warn you, Eileen. You're not allowed to take any form of lighter or matches into the courthouse. So if you get off a plane and you don't have a hotel room or anything, and you get a ride to the courthouse, and you try to go in, they're going to throw out all of your lighters and matches right there in front of you. Then you go and you watch court. Then you get back on the plane. And you are totally screwed until you get home. Just saying. Just saying. That's going to happen to you, so be careful. Hide it or don't hide it. Don't.
First, we have a reckless driving. Then you pick up a gun case. Then I tell you to drug test, you fail to go. And I tell you, look, buddy, you have to go. Otherwise, there's a consequence. And yet you fail to go again. Guess what happens now? You go to jail. Goes with you? Deputy Williams. Sorry to keep you waiting. You ready? Hey, what's the word, Thunderbird?
I'm here on Mr. Ramos, Ramos.
Okay.
It's that DWI case, client's been in ICE custody, so
Yes.
they made a thinking about it, they made a time served document, so.
Do you want me to bench? Is he in ICE custody now?
He is in ICE.
Do you want me to bench warrant him so we can take care of it?
Great, yes. that'd be
Okay,
great.
we can do that.
They'll bring up, but yeah.
Because that way, at least if he's still
Very,
there,
very
we
pretty.
can try to get him back. We can try to take care of it. That way he's not.
There is an offer already, yeah, I got a chance to.
And then, you know, what we can do is as soon as you get him back,
Those type of things, they smash satisfyingly when you get mad. They just do. Leanness. They just, you know, when you throw it at someone and it hits the wall, it smashes very satisfyingly.
back, or hopefully, because I don't know for sure.
Right.
Just get a immigration lawyer lined up with the MAC ready to go?
Definitely.
That way, as soon as he gets here, we can have him advised and then, okay.
Right.
Hi, Mr. Baylor, you ready?
Racinos.
Okay,
This is a
is this the?
MRP. plus-
Yeah.
Judge, it looks like you only have 97 days. He's been in jail for 145 days, just so the court knows, on the felony. How to do whatever anyone tells me to do. But
I unset termed him because there's just no, but what was the last name again? Racinos?
and he's not here today. His felony is the same day, so I will just do whatever anyone tells me.
Sure. I mean, what are they, is there a global offer?
So not based on my understanding, Judge, and I'm not the one signed to it, the prosecutor signed to it is offering a probation on the video.
And he's been wanting to take that forever. I know there's he just keeps getting reset. He wants that. I would run up there and help him myself. I might as well just do that.
You mean a probation upstairs?
Upstairs, and then-
He wants to do a probation on the felony case or this one?
He has a 3-year deferred offer on felonies. He wants to do that and has wanted to do that forever. There's just some beef with. No, but hey, where are you, attorney? Just get a reset.
Come on, man.
I know. So I can run up and talk to him.
Don't. It's.
I know it puts us in just like a. That's why I just say I'll do whatever I'm told to do.
It's not the same transaction, right?
He got that second.
Why don't we set it for trial? That way you can
Is that
make them
right?
work their butts,
Congratulations.
you know, because otherwise, I mean, it's not the same transaction. Are they really gonna make this go?
And if we do it trial, and we're giving him credit for what he's been in, we're at 435 days.
Absolutely.
Yeah, I know.
Set it. Just set it. You set it. Whatever day you want, just sooner rather than later. I mean,
The update I got as of 11 is they're obviously doing the discussion on the third day, but we are free to do our DWI, which is the probation officer that Barbara was talking about.
oh, do you want to do the probation then?
My client's just not here for me to.
Well, no, but I can set it tomorrow. Or no, Friday,
Damn.
because I'm not here tomorrow.
Hold on. I know I was close.
Okay, yeah, Monday.
Yeah, okay.
All right. Let's hook them. And then we'll do it all together. Philip,
Good morning, Judge. Can you hear me? Did I unmute myself yet? How are you, Judge? Am I on mute? Nope. Perfect. I'm not.
I got you, yeah.
Good to see you. Love that jacket. What is that? Floral print?
Thanks. I don't, yeah, floral.
That's great.
Thanks. Hey, Guerrero, are we done?
We're waiting. I've submitted everything. The last
Guerrero.
information I have is that Cynthia.
Close. It was close. I mean, I wasn't close, but that is congratulations. And this is colonized. So they both start with G. That means I was right. No, it doesn't. It means I was wrong.
Emailed Chief on February 27th asking for a decision about our application for PTI. I got an email automated back this morning when I followed up that John's out today. So I don't know if we have a visiting chief that might be able to make the call.
Nothing
Or
yet.
has John maybe made the call and put a note in the office, in the notes?
An email.
I'm hopeful that Dutch swear words have many, many, many more letters in them.
Sent to chief. That was February 27th. I don't have any update as to the
So let's do this. Let's set it to Monday. If no decision Monday, then I'm gonna email them myself and figure out what the hell's going on.
Perfect. May my client's appearance be waived? And may I
It'll be
appear by Zoom?
waived. Has he done a TRAS yet, Phil, or no?
I don't want to lie to you. I'm not sure.
So, Guerrero, page 9. So he has not done one yet. So if he's accepted, he needs to be here to do it. If not, and there's still no decision, it'll be waived.
Okay. Perfect.
Okay.
All right. Thank you, Judge.
Okay, man. Have fun.
See you Monday. Bye.
See you then. Taylor.
Judge, how are you?
What's up, bud?
Doing good. I missed your Galvin. It's a BPR.
Okay, let me just send this real quick.
I know bilingual is when you
Patrick,
speak
come up.
two
We'll have you
languages,
sign your
but what
conditions. We're
is
sending you on your way.
when you speak half of one language?
Up here to the
What's
clerks.
that? What is that? What's the word for that?
Okay, Taylor, what was the last name?
Galvin. Maybe Galvin. He's not Judge Ivan Costin. But this is the one that you wanted to send on Friday. I couldn't be there Friday, so we pushed it out to today. So
God, okay, what's the cost number?
2599-865.
Because that's me. I speak half of one language. And most of that is swear words. Semilingual.
Come up, Mr. Galvan.
English.
What is the one thing you were ordered not to do?
Don't drive. Do not drive. Do not drive. Don't break.
I've had conversations with my client. He is a heavy smoker. He's been smoking, since he was underage. He said the last time he did smoke was the day that he got picked up, Judge. I don't know if we're.
Damn it, it was drugs. I had driving and I had protection order and it turned out to be drugs.
Able to see the specific levels from this test to when we got tested initially. It should show a decrease. I've had conversations with him. I let him know honesty.
It's been 65. Oh, hold on, let me see. The bond conditions were placed on 1/9. We told you not to use on 1/9. So there's 30. There's 60. It's been
Grams?
62 days. 60 days.
And I explained to him, and I told him, hey, look, we need to be honest today. Honesty is the best policy. He is very adamant that the last time he smoked was the first day that he showed up to court. I wanted to see if we can get some type of drug testing on the testing levels. I see it on this, but I don't know.
He was tested today, right?
No, it was tested on the 4th. Yeah.
Okay, I'll give you the benefit of the doubt. I'll send him now. But if he's testing positive, then he's still using.
So the point I'm trying to make in that to see if we have the drug testing from when we initially tested.
How many
I
grams are
don't
in
care
that?
about all that. I care about now. You're supposed to be negative now, not. Then it should be negative.
I'm being honest with you.
Everybody's being honest with me here. You know what I mean? Everybody sells me the sun, the moon, stars, snake oil. That's what they do. That's the line of business we're in. This is a court. We work on proof, not on gospel spoken word. Your words mean nothing to me. Actions speak louder than words. You're on bond for a case we ordered you not to use. You're either dirty or you're clean. It's black or it's white. There's no gray. I'll give you the benefit of the doubt. I'm going to send him now.
Babble.
And we can roll to tomorrow because it's late now. But if you put anything in your body, you better know damn well what it is. Because if it's going to cause you go dirty, it's going to cause you go to jail.
Judge, I will say he's working 10 jobs. This is his first charge after he's 20 years old. I have told him the same stuff. I have said, hey, look, let's go in here. He's honest.
No, Miguel. Oh, you
I'm
can't
smoking, but you're not smoking. I
hear
mean,
me.
He's saying no. So I'm going to test him and I'm hoping that it's negative. Well, let's see. I don't know. Maybe it will be.
Just got tested on the 4th. Can we at least?
I have tested people where they've tested positive on Wednesday, then I test them on Thursday, and then they come out negative. Because believe it, there are false positives that happen, and I'm willing to give you the benefit of the doubt. I mean, if it's I hope it's negative. I don't want to put you in jail, but if I don't, then I'm telling you it's okay for you to continue to do what you're doing, and it is not. Bond conditions are there for a reason. For you, no, I don't care. It goes in one ear, it goes out the other. It's black or it's white. You either do or you don't. There are no mistakes in this life. There are choices. You either make a good choice or you make a boneheaded one. And you know what you put in your body could cause you to go to jail. You know this. I've told you 15 times. Sit. We'll send you for a test now. We'll see you tomorrow. I'm hoping and I'm crossing every damn foot toe I have that it's negative. Only you know. I'll see you tomorrow.
Thank you, Judge.
Please.
I love that word.
Counsel, you
Durango.
ready?
Yes.
Come on.
I'm going all seven.
Is this from yesterday?
It is.
Deputy Williams, did you find someone?
Yes.
Do you mind bringing her out, please?
Delora. Found her father actually here today.
Wonderful.
He had an emergency and has to leave right now. I know.
Look,
It's a prime
I wasn't
minister.
here.
Dog.
if you've got a place for her to stay, great. He's willing to take her.
Yes.
Then I'll give her a PR bond,
Okay.
but I'm only doing it once.
I understand.
And she'll be advised that it's not a revolving door.
Oh, poor Oscar.
So. Oh, you made it. Wonderful. Good job. I'm happy that you did, because I didn't want to have to revoke. Good job. I'm glad that you did. Great.
I like Venus as prime minister.
She did well, huh?
Well, we did the reset for today, so she might be in the one.
Oh,
The 8th.
I would say.
Yeah, buddy.
We'll do whatever the original date was before. Call Lori. How's jail? When you don't appear, this is what happens. We don't ask much from you. You have to show up and you have to stay in contact with your lawyer. And when you fail to do it, you end up in orange. It's not a revolving door. Do you understand? I will give you one more chance. However, you will get a GPS monitor on your ankle so I know where you are. And I'm telling you, if you take off on us again, you know now your bond would literally $100 to get you out, and not even, no one's even ready to put in $100 to get you out of jail. So you know if you go to jail, you are there to stay. Do you understand? No drugs, no alcohol, you will be tested. If you fail to appear for the drug testing, what happens?
I'm gonna go back in here.
Very good. Like I said, all we want you to do is stay in contact with Mr. Henry. He will tell you when you have to come back to court. Do not pick up any new cases and don't use. And no engaging in the like behavior which got you here in the first place. You understand?
What's that?
Okay, good luck to you. Thank you, Mr. Henry.
Thank you.
Hi. Good morning.
I'm here on the docket first for Avery, last name.
What's the last name?
Last name is Avery.
Avery.
Very old case. Before we set it for trial, but we just got a PTI offer 3 online classes.
Okay.
We can set it or we can just.
No. I mean, if you got a PTI offer, is the person here now?
Yes.
Do you mind bringing them up?
No, he's got one about him. He said.
Avery.
I'll get him.
Oh, he might have got to the back.
So how long do you want? Reasonable. What is it?
2 weeks.
Fine.
Okay.
But that's it. If it's not done, I'm gonna bring him back so much, he's gonna think coming here is a career, day after day.
And the only other thing I'm looking for is I want to ask her mom if you did in case that Mr. Damien said it and out and I'm waiting. but I'm here for you.
Okay.
He says he's waiting for the NCI slate report that is taking a lot.
This on who, what's the last name?
The last name, the person is Colby Armstrong. And they all came from New Orleans to speak here. His girlfriend is newly pregnant, very long.
Reckless operation of a vehicle. Okay. I guess let's wait maybe 15 minutes and then I'll reach out and we'll see.
Okay.
Mr. Avery, come on up. You know, considering you've been gone for as long as you have, you are extremely lucky to get the offer that you have for them to dismiss this case against you. 3 classes and then this case will get dismissed. You have 2 weeks to get it done. If you don't have it done in 2 weeks, I'm going to roll you day for day until you get it done. If you don't get it done, you're going to come Wednesday, then you will come Thursday, then you will come Friday, then you will come Saturday. Do you understand? Okay, see you in 2 weeks. Mr. Fernandez, you ready?
Good morning, Ron.
Hi, good morning.
This is an off-document request, Your Honor. My client is set for Friday or Raymond to solve that member case. I want to expect a movie for tomorrow. So I'm not gonna give it
I'm not going to be here tomorrow.
okay.
Can you zoom in Friday?
I'll be traveling. So I don't want to be driving and.
I mean, do you have the case number?
Yes, Judge.
What is it?
It is 2609-348.
Well, that's a high bond.
I think it was a high PR bond.
So I'm gonna, it looks like probable cause has already been found.
Right.
Yeah, so what I would do for now, because I'm still gonna do it, but I'm gonna, no dope, no alcohol, random testing,
Thomas?
and then, no contact for now.
Well, that's why I wanted to be involved because the complaint witness reached out to me. And I wanted to see, if she wanted to bring and provide me testimony before, because they share children together. And that's why, that's why I wanted to do it via Zoom, even though I can't, I wouldn't do it via Zoom, because I want to be present when she finds me.
Well, you are you are in Zoom.
I can't stand Zoom. But I'm just looking at the screen, feel like I'm not participating, but advocating for my client. Can we do it Monday?
What do you think?
Not opposed, Judge. In the meantime, we have spoken.
I mean, I don't know. There's not even an order for protection that's been entered.
I thought there was a MOAB in place.
It's not been signed
By a judge or
by him.
No, he's been compliant.
See, it says here that he's not to have contact with this person, so I hope he's not having contact with
He's
her.
not.
Okay, I'll roll you till Monday, that's fine.
Thank you, Ron.
Just let him know
I'll let him
that
know.
he's got to be here Monday. Just be aware that no contact order, because if not, then he's going to pick up a new case.
Absolutely.
Yeah, okay.
Thank you, Ron.
Yeah, just let
Appreciate it.
Victoria know, for sure. Allison,
Yes, I'm here.
hey, dude.
Good morning.
Morning, what's up?
Well, so this case was supposed to be dismissed as as part of the felony deal. And so
Is it on docket today or no?
it is John Ball.
Ball, you want to check that out?
Yes, Judge.
Sure.
So I just, I emailed the felony prosecutor last night and then I emailed her again just now saying, hey, I thought this was going to be dismissed.
Sorry, maybe a lot of times they're supposed to get it, they're supposed to dismiss it, I don't know. And they don't.
Yeah, I think it was just the felony DA just didn't dismiss it.
I do have no felony about dismissing or felony punishment, yes, but I think following his house, shit, we got to it.
He's in jail. Gotta get to it today.
Okay, but are we looking at jail time, Granny, or fines? Or community service? What would the punishment be for this crime?
Yeah,
He's in jail. I mean, it's a matter of him getting out.
I will,
Oh, wait.
Or, let's do this. Can you reach out to Bernadette right now?
yes,
I don't want him to sit and wait.
yes. Absolutely, Judge.
Judge, he's not dry sitting, as they say. He has a few couple more weeks to do.
Oh, he does?
Yes.
Oh, okay.
We have an open felony that we're about dismissing for felony punishment. It's figured under the law.
Got it. Okay, I was concerned that he's being held.
I do legal stuff too. It might not be legal in Pennsylvania, but it's legal somewhere.
Okay. So
I
what do you-
really appreciate that. Thank you for being so concerned.
Well, of course. Do you want me to roll?
What is that noodle called that's just thicker than spaghetti bucatini? Is it bucatini? Bucatini noodles? That's what we get. Bucatini noodles.
Tomorrow, do you want to wait till later today? Allison, you tell me.
Oh, it doesn't matter. If you want to roll it to tomorrow, that's fine, but it should be dismissed by
Can you
then.
just, that gives you a little bit more time? Just make.
What a coincidence, Bren, because we're going to start our own extradition company. Because we can charge $15,000 to extradite someone. And we're going to make a lot of money. We're just waiting for somebody to head it up and plan it and get all the money from everybody and buy the vans and get an EIN and a fictitious name and permits, and someone has to carry a gun, and we don't have to buy handcuffs. I'm perfectly confident that out of this chat we own enough handcuffs already.
Sure that they, yeah, please. Okay. All
Thank you
right.
so much.
Thanks. Have fun. Yes, ma'am.
Well, that went freaking quick. It's over. The whole stream is over. We just started. Didn't we just start? But they're delicious. Real thick pasta. Yeah, if someone would just head one of them up, we'd all be rich by now. But no one listens to me. Nobody listens to me. We should be the owner of 17 businesses right now. Yep, we should. We should all be rolling in dough. Like at least $50 a month, each of us. I like how you think, JK. I listen to Bobby and Bren. Abso-freaking-lutely. What are you knowing about? Oh, the furry guy. No, that you said that. What are you knowing about? $50 a month? $50 is $50, Josh. What do you have to do right now for $50? Think about it. Probably not something pleasant. I love you, Jude. So you make $50 a month, Brad? Holy cow. How many grams is that? How many grams is $50? Wait, is your money heavier than ours? Because of all the colors? Don't you have a lot of colors in your bills? Your bills are more color. Ours are green and white. But they're cloth. But that's beside the point. I wonder how many grams difference your money is to ours. No, I don't. I'm done wondering that. I'm done. I'm moving on. Bread or cookie dough? Cookie dough. Bread. Bread. Cookie dough. Bread. Darn it. Terry, come on. I can't. All right, Eileen, you head it up. Find out who wants to put money in so we can buy a van. And a guard? I think we should have at least one guard. All right. And then we need a driver who has a driver's license and valid insurance. Because, you know, Judge Fleischer will kill us if we don't. Oh well, guys, I gotta go to work today. 2 servers on. That means we won't be very busy. We won't be packed. It's fine. A pink sparkly. Yeah, listen, if you're gonna be extradited by us, you're gonna be embarrassed. Yes. We're gonna have one of those speakers on the top of our little van that constantly plays "Breaking the Law, Breaking the Law." Okay, make a jingle. Okay, if we steal the car, then we would be extraditable. No. Yes, Miguel, absolutely. Say no more. Will you throw a little bit of speeding in that, please? Yep. But we need money. We need everybody to give money for the van. The vans aren't cheap. We could probably get one for $3,000. Probably. But it's okay because we can charge $3,000 to extradite our first person. And we made half of our money back already. Yep. Because we have to buy insurance, we have to buy gas, and probably if we're buying a $3,000 van, we're going to have to buy a catalytic converter. Can we take this opposite approach? Absolutely. I don't know. I don't know if driver's license will be good enough. Maybe we need a real ID and a passport to be able to drive now. The mystery van. We're extraditing criminals from one state to another, or one city to another. Who knows? We're charging $3,000. Oh yes, Josh. Maybe I'll come with you. Maybe I'll be your co-defendant and your lawyer at the same time. Oh, I just bought gas today, Brent. Jeez. Oh my God. I spent so much on gas today, and I have a tiny, itsy bitsy little car. Oh, it hurt. Oh my gosh. I bought gas today, and it gut wrenched me. I was like, I'm not in my belly. Like, what the heck? They just took all of that money from my account. I'd rather pay child support. I would never do anything to make Judge Fleischer mad at me. Do you want me to be your doctor, Miguel? I can be your doctor. You can have your driver's license back. Yes, JK, you should take medical advice from me as well. Because I watched every single episode of Grey's Anatomy. Yeah, I did. I might have fell asleep once or twice, but that's it. Whew, okay, guys, I gotta go to work. All right, well, I will see you all tomorrow night. Tomorrow's Sunday. So no morning stream, just the night stream. And then we're gonna have a good time. Thanks for coming out today, guys. It was a very enjoyable stream. And we can do it again tomorrow. Behave, guys, okay? Thank you. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace, come join the fun. 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so